these hearings with your legal mind. We did get the interesting note yesterday that the Justice Department has requested the transcripts of all depositions given and taken by this committee. What does that tell you about what may happen here once DOJ gets its hands on this case?
Yeah, it's not a surprising request, Willie. So there's a couple of reasons why the Department of Justice would want that. One, it has its own investigation. And so you want to know what all of the witnesses said on all the occasions that they were interviewed, right? If I were to interview you 3 times and you said things that were slightly inconsistent, it would be my obligation to tell the other side that if we charged the case using you as a witness. So you need to know what your witnesses have said. But as the Department of Justice noted in the letter, they also have ongoing cases, and some of the witnesses that the committee has interviewed might be relevant to that. So the Department of Justice has enormous investigative resources. It's not that they can't do the investigation without the help of the committee. It's that they need to know what the committee has already done because they have obligations in ongoing cases, and they want to make sure that witnesses have been consistent. It's a very logical request, and I am disappointed that the committee has not yet met the request.
Hey, Chuck, good morning. Jonathan Lemire. Let's get your assessment from a slightly broader viewpoint here, just of the hearings so far as they build this case, really damning case against the former president and how he inspired and incited the violence in the building behind me on January 6th. Do you feel like it is heading in the direction where, and Joe quoted from a tweet earlier from a former attorney, where an attempted murder charge could be assessed to Donald Trump if he were not Donald Trump and not in this setting, but at minimum, some sort of criminal referral could be produced at the end of this?
Yeah, Jonathan, I think they're getting closer all the time, right? The more that you talk to people who are around the former president, like Eastman, the more you know about what the president intended. You don't know it perfectly, right? So let's take Eastman as an example. This man gave horrible legal advice, but being a bad lawyer is not a crime. I mean, thank goodness for that, right? I'm grateful for that every day. But being an unprincipled or unscrupulous lawyer gets you much closer to a crime. Eastman knew, and we learned this yesterday, that his theory that Pence could reject electors was unfounded. He said he would lose 9-0 in the Supreme Court. He said that this recourse was not available to Al Gore as vice president in 2000, and he said it wouldn't be available to Kamala Harris in 2024. He also said that he knew his theory violated the Electoral Count Act of 1887, and yet he urged this on the president of the United States. And while he was doing that, other people told the president that what Eastman was advocating was unfounded, illegal, improper, and the president went ahead and pressed it anyway. So what you tell someone is evidence of what they knew. It's not dispositive, right? Jonathan, you could spend the rest of the week telling me all about quantum physics, and I wouldn't actually understand it, but you could honestly say you told me. But you're getting closer and closer and closer to what the president knew and therefore what he intended. And whether or not there's a criminal referral at the end of the day, I think you're beginning to see a very compelling case that the president of the United States, with others, conspired to obstruct Congress, to thwart the count of electoral votes, to interfere in its work, and if you can tie them to the use of force, to a seditious conspiracy.
Well, I was just going to ask Chuck, what does one have to do? I mean, to have the Justice Department charge you with a seditious conspiracy. The morning after, on January the 7th, I think I read it on the show. Let me just really quickly, 18 U.S. Code Section 2384, seditious conspiracy if 2 or more persons in any state or territory, any place subjected to the jurisdiction of the United States, conspire to overthrow, put down, or destroy by force the United States, or to levy a war against them, or to oppose by force the authority thereof, which they were trying to do, or to delay the execution of any law of the United States. Let me say that again. Or if their intent is to delay the execution of any law of the United States, or by force to seize, take, possess any property, they'll be guilty of a conspiracy to commit sedition. This is, I mean, my God, if any of us were given this fact pattern, in criminal law our first year in law school. And if any of us wrote, oh, no, this doesn't fit the four corners of this statute, our criminal law professor would give us an F. This is basic stuff. So, and from there, let's move on to John Eastman. What in the world does John Eastman have to do to be charged? Like, it is really, this is what he's doing is not just beyond the pale, not just un-American, it's illegal.